everyone, Sue Moran here, Falmouth Selectmen Chair, and we're doing another segment of State of the Town. I have with me today Town Counsel. Frank Duffy is great enough to have his first conversation with us at FCTV studio today, and then of course the Town Manager Julian Suso, who's been with me a few times. We're going to address the topic of the wind turbines, a little bit of the past, the history, where we are, how we got here, and what to expect in the future. Started back in 2010, Falmouth, very forward-thinking, green energy, erected turbines, later one and then another. A little bit later on, some litigation ensued, and at this point, some of that litigation is still ongoing, and I'm going to look to our legal expert, Frank Duffy, to just give a little bit of that history, if you would, Frank.
Well, Sue, the saga of the wind turbines really began when the first one, Wind 1, went up in the year 2010. As soon as it went up and started spinning, there were some comments made by people who lived in the neighborhood who had some objections to features of it, including sound and so forth. So I think the first response that the town had was what was called the wind turbines option process. And that was an effort by the town to put together a attempt really to mediate the situation. And there was a facilitator who was hired. People from the neighborhood, people with other stake interests in the wind turbines got together. And that process went on, I think, for about a year, but it didn't reach any particular resolution. And the wind turbine, Wind 1, kept operating during that period of time. Wind 2, which had been in the planning stages, came along, and it was built in 2011, and it started to operate in 2012. And shortly after Wind 2 went up, our litigation began. Now, let me just give you a little bit of background on where that came from. The Falmouth zoning bylaw at the time contained what we now realize was an ambiguity. The zoning bylaw said that in a public use district, and the wastewater treatment plant is in a public use district, the municipality or the town could operate any municipal purpose by right. Whatever they wanted to do, as long as it had a municipal purpose, they could put it up. So the feeling was at the time, and our interpretation of the bylaw was, that a wind turbine, which would generate electricity to run the wastewater treatment plant, in fact, was a municipal purpose. It was permitted in the district.
So just so I understand, the turbine first went up right next to the water treatment plant to provide energy to run the treatment plant, and this is all on municipal land?
Yes, all on municipal land. We have a 314-acre site up there off Blacksmith Shop Road for the wastewater treatment plant.
And it's also high, so that it isn't that usually a good, an optimal place to erect a turbine?
Right,
okay.
It was sited there because it was the highest point in town.
Okay.
And had the most wind.
Okay.
So it seemed like a logical thing to do. And the wastewater treatment plant, of course, runs by pumps, and all the pumps need electricity. It's a huge user of electricity. I think it's the largest single user of electricity in the town. So there's also a provision in the zoning bylaw that said that a wind turbine, or a windmill, actually, a windmill, was allowed by special permit from the Board of Appeals as an accessory use, which the building commissioner interpreted to mean privately operated windmills. It felt because the bylaw permitted all municipal purposes in the district that would include any municipal wind turbine. Well, that sort of became the focus of the first case. The neighbors up on Blacksmith Shop Road went to the building commissioner. They informed him that in their opinion, a building permit was necessary, or a special permit from the Board of Appeals, rather, was necessary for Wind 1. He said no, he didn't believe it did. I went to the Board of Appeals on appeal from his decision. The Board of Appeals affirmed him and said no, a special permit is not required. We then had a trial in Superior Court in January of 2013, and the judge agreed with the Board of Appeals and said no, a special permit is not required. Finally, the case wound up in the Massachusetts Appeals Court, where we had oral argument before a panel of judges, and that court changed the litigation around. They reversed the Superior Court and said no, a special permit is required for Wind 1. Wind
And what
1
was the
only.
year of that decision?
2015.
Okay, thank you.
Now, so the town now is in a situation where it needs a special permit for a structure it already has paid for and erected. So we went to the Board of Appeals and sought a special permit for Wind 1. But of course, at this time, we did so in the context of all the other complaints that had been raised by people who lived there about noise and nuisance and so on and so forth. So the Board of Appeals declined to issue a special permit for Wind 1. So Wind 1 is standing there, it's up, it's capable of operating, but it doesn't have a permit to operate. And basically it had to stop operating because the Board of Appeals declined to issue a special permit for it. Wind 2 was continuing to operate, although it was operating on a limited basis because the court had issued a preliminary injunction in one of the cases limiting the hours of operation to 7 a.m. to 7 p.m. and it could not operate on Sunday, Thanksgiving Day, Christmas Day, and New Year's Day. So there was that limited operation. Now, there was a number of other claims brought. There basically are two categories of claims. There's a concept in law called a nuisance. And a nuisance basically means a person owns property and uses that property in a way that interferes with somebody else's use of their property. So in theory, what you're saying then is that if the town has a piece of property and it has a windmill on it, or a wind turbine, which somehow or other interferes with the use of the neighbor's property, whether it be noise, vibration, even loss or decline of property value or something like that, under the proper circumstances, it can be declared a nuisance. And there's two types of nuisance claims. One is under the zoning bylaw, and a nuisance under the zoning bylaw is something that our Board of Appeals can rule on and can abate. The other claim of nuisance is a common law nuisance claim where you go to court, you file suit against the town, and you seek money damages for the nuisance, and that goes to a jury and is tried through a jury, and the jury can award the plaintiff money damages for the nuisance. So the wind turbines generated about 6 nuisance cases. 3 of them were of the zoning nuisance type, and 3 of them, or 3 or 4 of them actually, are of the common law nuisance type. There was one main one. It was entitled The Town of Falmouth versus the Zoning Board of Appeals and Funfar. That's Barry and Diane Funfar, who live on Ridgeview Avenue, West Falmouth. They raised a claim that the wind turbines were a nuisance under the zoning bylaw. We had a trial in Superior Court. A judge ruled that their claim was valid and ordered Wind 1 and Wind 2 shut down. So Wind 1 and Wind 2 are not operating right now. The Board of Selectmen decided not to appeal that particular decision, so that hasn't changed. There are 2 other zoning nuisance cases out there that have not been tried, that likely will not be tried, although their fate has not been determined officially. In the meantime, there were a number of cases going through the court system which are the common law nuisance cases. And these are where the plaintiffs, who are residents of Blacksmith Shop Road or the Craggy Ridge neighborhood in West Falmouth, allege that the nuisance value, or the nuisance of the wind turbines, has caused them monetary loss, and they want some monetary compensation for their loss. The first trial was about a year ago. It was in Barnstable Superior Court. It was the Andersons, Neil and Betsy Anderson, who live on Blacksmith Shop Road.
And just a quick question, when you say that turbines cost monetary loss, would that be based upon an argument of a lowering value of real estate?
Well, it would be based upon an argument of lowering the value of real estate, but also particular discomfort, personal discomfort, loss of sleep, loss of quiet enjoyment of your property, inability to, live your ordinary everyday life without interference from some source outside the property.
Okay.
So that case was tried to the jury in Superior Court in Barnstable last summer, I think it was, and it resulted in a verdict for the town. which is kind of inconsistent with the decision in the other case, which found that there was a nuisance. But you know, all of these cases are independent of each other. They relate to different properties. Different people are the parties, and one doesn't control the other. So if you have 6 or 7 cases relating to the wind turbines, and it's different parties, different property, different circumstances, you can get all these inconsistent results.
So in those 6 or 7 cases, what's the total amount of plaintiffs or people or neighbors involved?
I think right now there's probably about 8 or 9 people involved, although at one point, based upon letters that the town had received from people who said they might file claims, I think there's a total of about 22 people who have put us on notice that they might have claims.
Okay.
But we've only heard officially from about, I think, less than 10.
Okay.
So there are 3 other common law nuisance cases that are scheduled for trial sometime later this year. This is 2018. And with respect to these common law nuisance claims, the town's insurance company, the Massachusetts Interlocal Insurance Association, has taken over responsibility for defending the town. And if there are money damages, they would pay damages up to policy limits.
So
now,
to date, has there been any judgment of money damages?
no.
So even in the case that where the plaintiffs, the neighbors, were successful, there was no money damage
No money damages.
judgment?
The only thing the court did was issue an order that the wind turbine shut down.
Okay.
We have not suffered a monetary judgment in these cases.
And also, Frank, did the court not also rule that there was no diminution in property value?
That's true.
Which was
in
very significant, it
right,
seems.
yes. The judge specifically found that there was no diminution in property value. And that was in the Fun Park case with respect to his property anyways, which is on Ridgeview Avenue in West Falmouth.
Okay.
So there's also, just for everybody's information, whenever you sue a municipality or a governmental agency in Massachusetts, there's a cap on damages, and it's $100,000 per person. So you can go into court and say your damages are $500,000, but the most you can walk out with is $100,000 if you win.
And would that be paid by the town or the insurance
It'd be
company?
paid by the insurance company. However, if we were to suffer a number of judgments like that, I'm sure our insurance rates would go up next year, but no, the money damages would be paid by the insurance company this year.
Okay. So where we're at right now, you said about 3 cases?
We have 3 cases that have been noticed for trial sometime this summer. I can't give you dates because the court hasn't specifically assigned them. Our insurance company is vigorously defending them. They intend to make the plaintiffs prove their damages and convince a jury that they're entitled to some monetary damages. And that's the plan going forward with respect to those cases. The other cases are in various stages of trying to wrap them up and dismiss them and end that litigation.
Okay, so, you know, from the Board of Selectmen's perspective, it's kind of a moving target. We're sort of in transition where we're still under, you know, the guidelines of executive session in terms of the ongoing litigation. So there really is a limit as to, you know, what we're allowed to make public. So, you know, this program today, you know, we're really trying to do the best job we can to let folks know, you know, where we're at in terms of the information and also the litigation, because it's been very expensive, and that's something that, you know, town meeting, you know, periodically has to allow, you know, payment for attorney's fees, but you know, and that's going down because the cases have gone down. But we also are looking ahead to the finances of the town and what we have in store. And I wonder, Julian, if you could jump in here and let folks know where we are with the obligations. And I know that, you know, you've been really guiding the board in terms of what kind of resolutions we might be able to have with the state on our on the notes and other turbine-related you know, obligations, let's just say.
Certainly. Happy to update on that, Sue. As you know, the Board of Selectmen has tasked me with the mission of dealing with and bringing to closure to the maximum extent possible the outstanding financial obligations of the town. And the two that are we've been actively working on because we can have some movement there is first with the Massachusetts Clean Energy Center. That Mass CEC advanced the town about $1 million in the early phases of the process, which the town utilized, I believe, not only for construction but also for some planning and site preparation, et cetera, in anticipation of acquisition of one and ultimately two turbines. And in addition, there was an agreement with the town that allowed that money to flow from the state money from the Clean Energy Center to the town of Falmouth. In addition, in that agreement, the town owed the Clean Energy Center what are called renewable energy credits that come about from the regular operation of, in this case, Wind 1. The agreement with the Mass Clean Energy Center, or Mass CEC, only was in regard to Wind 1 and not Wind 2. So we've had an agreement which has had to be renegotiated on a couple different occasions because of the legal challenges that Frank Duffy has described already. And at the end of the day, our obligations under the original agreement to the Mass CEC were well in excess of $1 million, particularly that original $1 million, plus the renewable energy credits, which are worth a substantial sum of money as well, and for which the town was obligated to deliver over multiple years to the Mass CEC. And really, we were only able to deliver those credits in partial form because of the reduced operating time that a court had ordered, as well as suffering the setback where we were not granted a permit to operate. So during that limited window in which Wind 1 did operate, we had some renewable energy credits delivered, but much smaller than the agreement provided for, and certainly a much shorter term. We are now negotiating. I am working with Town Council and also our Finance Director with representatives of the Clean Energy Center as authorized by the Board of Selectmen, and we hope to have a final settlement with the Mass CEC here in the very near future. It is also a matter that we're carrying a piece of that proposed settlement forward into the April town meeting, and that's a warrant article which we will be discussing at town meeting as well. The other piece, the other major state agency we're dealing with a financial obligation is the Clean Water Trust, and they originally had a different name, but they've become the Clean Water Trust. They were the vehicle through which some federal ERA money, that was the funds made available to states and localities during the recent recession, those funds were delivered as a technically a grant with the potential for interest payments, but they could be forgiven and relieve the town of any need to repay a grant. It's about $5 million in this grant, in these federal and state ERA grant funds. And that's ARRA, ERA.
So part of, just if I could
Sure.
interject, so part of the funding, I imagine from the state's perspective, was to promote renewable energy, which would have had a requirement that the turbines actually run for these funds to be used and kept in Falmouth. And so when there was a court order that mandated that the turbines either run for fewer hours and eventually not run at all, that was what triggered really the state, agreement kind of being, Falmouth just really having no ability to further that part of the agreement.
Correct.
Okay.
And that was a standalone agreement, in this case with the Clean Water Trust. And I should note that this $5 million grant, which had potential for principal and interest forgiveness, did require, as you've noted, that Wind 2 continue to operate as an energy efficiency project. And even with limited hours, we were certainly making every reasonable effort to continue to operate it in that manner. However, when the court-ordered shutdown occurred, and Wind 2, as Frank has noted, is also not spinning, when we notified the Clean Water Trust, they indicated that at this point they still feel that the town has an obligation under that original agreement for a very large portion of that original $5 million. And that is a matter that we're going to be continuing to discuss with them. Over time, we've given them all the information about to demonstrate the town has made every reasonable effort, but we are barred by a court from operating it at its current location. So that's the circumstance there. In addition, financially, I should note the $5 million grant underwrote the acquisition of Wind 2. Wind 1 was essentially purchased and funded by borrowing by the town, and the town borrowed about $5 million to underwrite the cost of the Wind 1 acquisition, and we are paying that back on a municipal bond over a 20-year term. We have about between 10 and 12 years left on interest payments on that bond, and they're approximately $400,000 a year. So there is no mechanism for the town being relieved of that obligation because it is a general obligation of the town as a whole, and the town borrowing was authorized, of course, by town meeting, and the bonds have been issued. So we have that responsibility to the bond holders, and that obligation is going to continue, as I note, for the next 10 to 12 years, and is becoming a standard part of our annual operating budget to meet that obligation.
Okay, so that's, you know, complicated finances, trying to be drilled down into a basic where we're really got some forgiveness from the state we're working on, and then other aspects we really just have to budget and do the best we can going forward.
Correct.
You know, certainly I know in terms of renewable energy, the EDIC is working on the second project, similar to what was originally done at the landfill. So that's at least an energy efficient green project the town still is moving forward. But in terms of, Frank, going back to the litigation, is there anything at all you can say in addition to the original efforts to try to resolve these cases? I know you mentioned there was a wind turbine mediation process at the beginning before the claims?
Yes, at the very beginning there was a wind turbine options process, which was basically a group of people from the immediate neighborhood of the wind turbines, and it also included people from other parts of town who had other interests. For example, people who were promoting renewable energy or just wind energy in general were part of it. And I think a member of the Board of Selectmen attended all of the meetings. There may have been other municipal officials who participated in this. That particular process, the wind turbine option process, there was a final report, but it didn't seem to resolve anything. But there was another effort later on during the course of all the litigation where the town engaged a professional mediator, a retired land court judge. We took over a good portion of Highfield Hall one afternoon, one whole day actually.
Yes.
We invited everybody who had a claim against the town to come and to see if we could resolve the case the cases, all of them, amicably. We talked about entering into a global settlement, which would include everybody. But at the end of the day, we had not reached an agreement, and we never resumed that effort. But we did try. It's very difficult to settle cases like in this particular situation. We have a number of cases. We have a lot of different people. They don't all agree on what they want, and they have different views of the town and the wind turbines. It was a daunting task, and it proved to be daunting. But we certainly.
And Frank, no one attorney represented all of those neighbors as well,
that's one,
which also complicated.
Right, that's
the
true,
challenge.
Julian. There were a number of parties with different attorneys representing them. There may have been too many people to expect an agreement out of that effort, but we tried.
Well, and now moving ahead to the current situation where there are a couple of cases that we're optimistic will be wrapped up fairly soon. But in terms of the present situation, for example, the building inspector has made an order with respect to one of the turbines. Do you want to
Yeah.
give us a recap
Wind
on that?
1, as the status of each Wind 1 and Wind 2 is a little different. Wind 1 has two problems. One, it doesn't have a special permit, and when we applied for a special permit from the Board of Appeals, they denied the special permit. The second problem is that it was declared to be a nuisance by the Superior Court in the Funfar zoning nuisance case. Mm-hmm. So Wind 1, in my opinion, is done. It's never going to operate again at that location. We have to figure out some disposition of it, but it eventually will be taken down and moved away. Whether or not the tower it sits on can be reused or repurposed is something we have to look at, because, as Julian pointed out, there's a $5 million investment here, and we want to try and recover some of it if we can. But Wind 1 it's gone.
So what is the timing that the building inspector gave?
The
with
building
respect to
inspector gave the town till May 30th, I think it was, to come up with a plan to remove it, and then the Board of Selectmen authorized the town manager to secure the services of a consultant to try and advise us as to what we could do and what our options would be with respect to Wind 1. That's the wind turbine.
Okay, and so Julian, I think if I recall, in the past there might have been some engineering studies done. Is it the case that we would pick up on that and fine tune it, or what would need to be done in terms of any kind of study?
Well, we've had multiple consultants working on behalf of the town prior to the erection of the turbines. I think the last major study was, I believe, December 2011. It was finally issued. It looked at mitigation options for the wind turbines, and that was by Weston and Sampson. And one of the things that I'm hoping to have the Selectmen's concurrence to do is to bring in a qualified engineering consultant like a Weston and Sampson, for instance, that's done a lot of work and is already quite familiar with that site, to look at options primarily for Wind 2, since Wind 2 is in a little different circumstance. Frank hasn't fully described that, but it is a different situation. We have a circumstance where Wind 2 has been declared a nuisance at that location, but we've been affirmed at least on 2 occasions as not requiring a separate permit to operate, although that's being challenged as we speak. We've had the Zoning Board of Appeals and I believe a lower court had affirmed that. So if I'm able to go forward, I would have Weston and Sampson give some consideration to whether Wind 2, for instance, could be located anywhere on the 300-plus acre wastewater plant site at some location potentially furthest removed from any occupied residences. That is a focus which had not been previously engaged in terms of location of the turbines. While both of these sites were in place when I arrived as town manager, my understanding is that primary drivers there were the best locations for wind on the 300-plus acres, and a number of locations were surveyed, as well as locations that were most optimum, or I should say optimum, in terms of maintenance access and connections to the grid and some other issues like that, but strictly focusing on location as it relates to minimizing any potential for nuisance. I don't think that was, my review of the reports indicates that that was not focused on in any detail. And I believe if selectmen concur, I would like to be able to provide that information to them because conceivably Wind 2 could be considered for a different location under the new wind turbine bylaw, which was adopted by, recommended by the planning board and ultimately adopted by town meeting. And I know Frank is familiar with that element as well. So there's a differentiation in the way Wind 1 is potentially beset with alternatives as compared to Wind 2. And we also have that possibility that the existing mast for Wind 1 could conceivably be repurposed. That could be something looked at as well.
So when we last looked at this during the wind options process, what was that year?
2011, 12.
2011-12. So it, would appear the task would be to update that rather than focus on efficiency of the running of the wind turbine and low cost of installation, that there be a turn just to look at just potential locations primarily, and then look at the cost and secondary issues after that. So that would be left to do, just so we have all the information in front of us to make
Correct.
that determination. And what do you see, Frank, in terms of the differences between the two turbines? If you could give a recap on that.
Well, certainly, Sue. As I said, Wind 1 is finished. There's really no resolution of that other than to take it down, with the exception of the tower, which may be repurposed. I say maybe because we don't really have a plan for that yet. We're just looking into it. Wind 2 stands on a little different grounds. Like Wind 1, Wind 2 does not have a special permit, but the original court case, the Duffy case, which came down from the Mass Appeals Court, applied only to Wind 1. It didn't apply to Wind 2. A subsequent effort by the neighbors up on Blacksmith Shop Road to raise the issue of Wind 2 failed because the judge in a Superior Court case said, no, you came along too late. You should have brought your claim much earlier, and you're too late. So at the present time, no court has said Wind 2 needs a special permit.
So just go back to that. Is that what you call the latches
That's
case?
the latches case.
And
Latches,
what is the legal meaning
latches,
of that?
I guess, is a Latin word for you sat on your rights too long. In other words, if you wanted to challenge the town putting up a $5 million wind turbine, you should do it before they do it and spend the $5 million. Instead of waiting till it's up and operating so that they've spent $5 million, it's now in jeopardy. It's an equitable principle.
Okay, and how long was it from the time it operated until the complaint came in?
3 years.
Okay, so that's why the judge decided against.
Right.
Okay.
Right. They were late. So that decision, by the way, is being challenged, but hopefully it will be affirmed in our favor. But right now, Wind 2 we have the option of perhaps moving Wind 2. Now, I want to point out that the town meeting adopted a new wind energy system bylaw in 2013. The new wind energy system bylaw specifically provided that any wind turbine lawfully in existence as of that date could be moved. We're arguing that Wind 2 was lawfully in existence as of that date. However, in order to relocate Wind 2 under the new bylaw, it requires a special permit from the planning board. So this is not a decision that the Board of Selectmen or the town manager or anybody can just make unilaterally. It requires an application to the planning board and the full effort of a special permit, which requires notice, public hearing, all kinds of engineering data has to be presented, and as Julian pointed out, if it's going to be moved, it's going to have to be moved someplace where there's not going to be anybody to see it or hear it, or it'll be far away from them. I know there's some concern out there that it may be just moved a few feet, but I don't think that's the plan at all. We're not looking to buy more litigation or more trouble.
And certainly the Board of Selectmen
Board of Selectmen don't want to do it either. So,
well aware of any potential issues.
Wherever it goes, will go only after a thorough study determining that it's appropriate for where it's going to go.
That's very helpful. Now, is there anything I haven't covered, and maybe you could give us a guesstimate about when the existing litigations might be done in terms of appeals?
I think they'll all be done in terms in the year 2018. Court schedules are kind of fluid. It's kind of hard to nail them down till you, but I think the plan is to have them done in 2018. I know our insurance counsel, Pierce Davis Peritano in Boston, who's representing us through Maya, plans to push for a resolution of these cases this year. And there's a couple of cases pending in the appeals court, the appeal of the Latches case, that are all scheduled to be heard sometime either late spring or early summer. So I think we're very close to the end of this saga, which has been going on for about 6 or 7 years.
And at great expense,
Yes, it's very
unfortunately.
expensive. Well, the expenses are kind of winding down now, but so that's very good.
Great. And Julian, in terms of work to be done going forward, what do you see as the time period?
Well, we'll be working closely with the Board of Selectmen in a couple areas, but mostly in preparation for completing this plan by the end of May that the building commissioner has requested to be transmitted, developed and transmitted. That is in regard to Wind 1. But at the same time, we'd like to be looking at alternatives, as I've already noted, for Wind 2, so that the Board of Selectmen has the appropriate range of options available to make, a wise and informed decision about what makes the most sense going forward.
Well, and I'll say on behalf of the board, I mean, this has been one of the most incredibly challenging and difficult situations to, to assist the town in dealing with in terms of what's certainly a compromise from both sides. So just really proud to be part of a well-working board that can say is doing the best it absolutely can in tough circumstances. So for that, I just wanted to mention to my fellow board members my gratitude. I think this segment of State of the Town was probably one of the most challenging, but really very necessary in terms of getting the information out, and it'll be ongoing conversation. So thanks for appearing with me. I appreciate it.
Very much so.
Thank you, Sue.